Hello everybody, thank you for joining us for today's webinar. I'm Darren Hamilton from Stone Group Lawyers and State President of AILA Queensland. Today's webinar is, the topic is Personal Injury Jurisprudence from the Plaintiff Perspective, Recent Developments in Public Liability Decisions from around Australia. Our presenter today is Travis Schultz, Principal of Travis Schultz Law. We're very honoured and delighted to invite Travis back to present for us again. Just some quick housekeeping before I pass over to Travis. Everyone watching the webinar, there's 120 of you at the moment, and that's increasing as more people come in. You're all in listen-only mode, so that which means you're muted. Travis will be running through some decisions in his seminar. If you have any questions, in the dashboard, there will be a question mark, and if you click on that, you can send through questions to me, and I will filter questions and raise them with Travis at the end of the session for a quick question and answer time before we close the session. This webinar is being recorded, and you'll all be emailed a link tomorrow by which you can view it again if you wish, or if you miss watching it this time, you'll be able to view it over a period of 48 hours. And it will also be made available to paid members of AILA on the website library after an embargo period. Travis has prepared a paper, and that will also be emailed to everybody in the days following the presentation. Travis's reputation, I think, precedes him. For the past 4 years, fourth listing in a row in the Doyle's Guide for leading in all 3 areas of public liability, workers' compensation, and motor vehicle law. Rather than run through Travis's impressive resume and experience, I just wanted to raise, for your information, some of the charity work that he and his firm are involved in. One of Travis's inspirations, the Spring Racing Gala for Wishlist, has raised more than 1.2 million since its inception. Travis has also has a cycling event, a Tour de Koana, which has raised hundreds of thousands of dollars for Cystic Fibrosis Queensland. And he's also raised more than $450,000 for Sunny Kids through his Winemakers Masterclass. He also sits on a number of committees and boards, including LifeFlight, the Queensland Law Society, Sunshine Coast Turf Club, and Matthew Flinders College. When I received Travis's new business card a couple of years ago, I was immediately impressed by the purple and champagne colours, as typical of Travis's restrained, memory-searing fashion style. I was fascinated to recently learn about the story behind these colours and the history they honour and pay homage to. Travis's grandfather, Jack O'Brien, was a wing commander pilot in the RAAF and fought in the Second World War in a unit tasked with the strategic bombing of Germany in one of the most dangerous fronts that the Allied forces fought on. Among the many bravery medals Jack O'Brien was awarded was a Distinguished Flying Cross, one of the highest honours a member of the RAAF can be awarded, and there are very few of them. To honour his memory and respect the family heritage, the purple and champagne colours of Travis Schultz and Partners brand are those on the ribbon of that cross. Without further ado, I'll pass over to Travis for this webinar. Thank you very much.
Thanks, Darren, and thank you for the introduction. For those of you online, I apologise that this modality of presentation lends itself to having more extracts from judgments appearing in a PowerPoint slideshow than would ordinarily be the case in an auditorium. So I hope you don't suffer death by PowerPoint over the next hour or so. If I do skip through some of them quickly, don't worry. we are going to arrange to send you a full set of the comprehensive summaries. I think Kylie at Ayla will send those around tomorrow. The plan is simply to zip through some of the recent decisions involving my definition of public liability law from around the Australian jurisdictions in the year to date. Obviously, given my background on the plaintiff side of the fence, that's the perspective that I take in terms of looking more at the cases that will succeed and those that will not succeed, and I guess trying to identify what elements need to be carefully considered if you're going to run a successful case. And I guess it's the converse situation for those who wear the black hats and usually work on the insurance side. In any event, the first one is a case called Cornwall and Jenkins. I'm hoping that Kylie can give me back control of the PowerPoint slide so I can run through those. Kylie, if you're listening. Doesn't seem to be moving for me for some reason now, even though we tested it. There we go. Got it back. This case involved a Court of Appeal decision in the Australian Capital Territory. A little bit of an unusual one. The plaintiff was injured on 11 February 2014 when she was participating in an aerial sling exercise class. And I had to get Baron to let me know what an aerial sling exercise class was all about before we started this afternoon. But as the primary judge at first instance observed, it's a fitness class where participants take part in exercises using a fabric sling, which is attached to the ceiling. And the plaintiff, while performing a particular and a more advanced maneuver, fell from the sling and landed on the floor, breaking both wrists. At the time, she was using a relatively thin yoga mat as fall protection. The studio where this happened had in stock both those thinner yoga mats and a thicker crash mat, as they called them, but the defendant did not require participants in these classes to necessarily use the crash mats. That was just left as a matter of discretion. In any event, after a hearing lasting some 7 days, the primary judge dismissed the plaintiff's claim and ordered that judgment be entered for the defendant, and of course on appeal became the respondent. And it was primarily on the basis that there had been no breach of duty established. The trial judge thought that there was a foreseeable risk of harm arising out of the class, but that the likelihood of the accident occurring was low, given that no one, according to the evidence, had injured themselves falling in this way in the time that the defendant had operated the business. And so the trial judge found that insistence on using a crash mat as opposed to the yoga mat was not a measure that a reasonable person in the position of the defendant would necessarily have taken. Now, the court considered the ACT equivalent of the Civil Liability Acts that those of us practicing in the eastern states are forced to contend with. And it was really a case that turned on this issue of the standard of care. And then, of course, the precautions that ought to have been taken. The court had regard to Section 42 of the Act, which provides that for deciding whether a person, the defendant, was negligent, the standard of care required of the defendant is that of a reasonable person in the defendant's position who was in possession of all the information that the defender either had or reasonably to have had at the time of the incident out of which the harm arose. Section 43 of the ACT, I'm going to almost call it the CLA, Civil Law Wrongs Act, provides that a person is not negligent in failing to take precautions against a risk of harm unless the risk was foreseeable, the risk was not insignificant, and in the circumstances, a reasonable person in the person's position would have taken those precautions. And then, of course, subsection 2 requires the usual shirt calculus as we know it from the common law. A consideration of the probability of the harm, the seriousness of the harm, the burden of taking precautions, and the social utility. The court then, of course, had to have regard to the provisions relating to causation, Similar provision to other jurisdictions, essentially that a decision that negligence caused particular harm comprises two elements: that the negligence was a necessary condition of the happening of the harm, the factual causation, and then, of course, the appropriateness or the scope of liability as well. Ultimately, on appeal, the court found in favour of the appellant plaintiff. The court considered that the risk of a fall from the top of the sling was, as the primary judge had concluded, plainly foreseeable. The expert testimony that the thin yoga mats provided were inadequate to protect a person from who was performing the level 3 hip lock manoeuvre from injury at the top of the sling. And a reasonable person in the position of the respondent would have provided adequate fall protection by way of a crash mat to protect against injury occasioned in a fall from the top of the sling. The risk of injury was thought that by not using the crash mats may not have been high, but in the view of the Court of Appeal was not low. The risk of significant injury if a person fell from the top of the sling was substantial. The Court of Appeal considered contributory negligence as well, and said that in the event that there was to have been a finding of contrib, as there ought to have been here, the failure to use a spotter and to not undertake the manoeuvre correctly by letting go of the sling amounted to contributory negligence, which the court assessed at 1/3. So not a small amount of contribution. The next one is a case of Carnamola. Now, this was back in New South Wales in the District Court. The plaintiff was a 40-year-old woman who suffered from a number of disabilities, which resulted in her having to bring the action by a tutor who was her mother. The injury had been suffered in September 2016 when the plaintiff and her mother were at the Nita City Shopping Centre, premises that were occupied and managed by the defendant. The plaintiff's claim was that she slipped and fell when walking along a corridor which led away from the female toilets. At the time of the incident, which was acknowledged to be 12:22 p.m, it was the lunch period and the busiest time of the day at that particular shopping centre. After her fall, the plaintiff told cleaning staff who were called to assist that she had slipped on water in the area immediately in front of the ladies' toilets, though when cleaning staff arrived, they couldn't detect any water present. The system of cleaning was a rotation of cleaners at 15 minutes and in the bathroom every 20 minutes. There were no records of prior slips in the bathroom area or in that area in the corridor in question. The plaintiff's claim was unsuccessful, and the issue of duty of care was not really in dispute. The plaintiff engaged an expert, but his report was considered to be rather unhelpful because it had been based on facts which really hadn't been proven. It was really a facts case in the sense that there was no doubt, according to the court, that the plaintiff fell, but it was just that there was insufficient evidence to prove that she had actually fallen on water in the corridor. But what was somewhat interesting was the expert evidence point. And from a plaintiff perspective, it really does resonate because it impresses the need to ensure that experts are properly briefed and that the material facts upon which an opinion of an expert is based are proven in evidence at trial. And here the court was scathing of the opinion of the expert, Mr. Byrne. The report was thought to suffer from a range of defects because assumptions had been made, and it was thought by the court that the expert's conclusions that the plaintiff more probably than not slipped in water are effectively a dogmatic and unproven statement, as opposed to demonstrating a nexus established by exposed reasoning between the relevant event and the specialised knowledge used to analyse it in the Dasreef and Horchar sense. The court thought that the failure of the plaintiff to prove the facts underlying the opinion deprives the court of an important opportunity of testing the validity of the process by which the opinion was formed. which accordingly reduces the value and the cogency of the expert evidence. It really does remind us of the need to ensure that when we're preparing these things for trial, we can actually prove each of the assumptions that is relied upon by the experts whose evidence is put before the trial judge. The next one was one of Shaw and Oakdale Junior Motorcycle Club, Inc. Again, we're in the New South Wales jurisdiction, although we're now in the Supreme Court before Justice Kavanagh. It was a rather sad case involving a plaintiff who suffered quite a severe head injury, which left him with a significant permanent brain injury. This happened while participating in a motocross event in 2004. It happened as the plaintiff was coming around the first corner on this track. His bike was clipped by another bike, which forced him to hit the jump at an angle. He came off his bike, but then another rider came over the top of him. He sued a number of parties, but by the time of trial, the only party that was remaining was the state of New South Wales. And the plaintiff's claim rested on an allegation that the state had improperly issued a licence to a motocross track which was not compliant with what were then the relevant standards and bylaws. It was said by the plaintiff that it was the track itself that had caused the accident and therefore his injury. The state, of course, denied this and relied upon a defence of an obvious risk of a dangerous recreational activity. Now, the plaintiff's claim was unsuccessful. It was a V for the D, so to speak. The plaintiff claimed that the state of New South Wales had relied on the opinions of representatives of Motorcycling New South Wales in inspecting and reporting on the facility. And the plaintiff said that therefore the state was vicariously liable as a result of the deficiencies in the reporting and ultimately in the granting of that licence. The plaintiff argued that insofar as causation was concerned, that had the track been identified as unsafe in July 2014 when the licence was granted, that the event in August when the injury occurred would not have been held and that he wouldn't therefore have suffered his terrible injuries. The argument obviously didn't succeed as the court couldn't be satisfied that if the state had properly identified the alleged non-compliances in the track at the time of the application for a licence and then refused it, that those creating the track would have simply abandoned it. There was every reason to think they would have just amended it and moved on, in which case the event would have gone ahead with most likely the same tragic outcome. It was found that motocross was objectively a dangerous recreational activity. It involves a significant risk of physical harm. It's an obvious one. The plaintiff tried to argue that the risk in question was not the risk of riding a motocross bike in an event like that, but rather argued that the risk was the risk of riding on a non-compliant track, and that the risk of riding on a non-compliant track like this was not obvious and couldn't be obvious to a person in the position of the plaintiff. So the plaintiff tried to create a new level of specificity to assist that aspect of the case, but it wasn't successful. The court found that this was a dangerous recreational activity. It involves a significant risk of physical harm. It was thought that regard must be had to both the nature and the degree of harm that might be suffered on the one hand, and the likelihood of the risk materialising on the other, drawing from the views of Justice Ip in Falvo. The expression constitutes one concept, with the risk and the harm mutually informing each other, such that the risk of physical harm may be significant if the risk is low, but the potential harm is catastrophic, or if the likelihood of both the occurrence and the harm is more than trivial, but the risk of physical harm may not be significant. The court went on to observe that an objective test is required in determining whether a recreational activity was a dangerous one. And it was thought that this was indeed accepted by the plaintiff in this case. The court went on to say that, in my view, the risk of being clipped by another bike and falling off would have been obvious to a reasonable person in the position of the plaintiff. Whether the risk is obvious is to be determined objectively, with reference to a reasonable person in the position of the plaintiff exercising ordinary perception, intelligence and judgment. So plaintiff clearly unsuccessful on that occasion. Another case that was a V for the D and another unsuccessful plaintiff, again in New South Wales, back in the district court, was this next one of Nihil, if that's how you pronounce it, and Vivian's model and theatrical management. The plaintiff in this case was a model who was managed by the first defendant, Vivian's. She was attending a photo shoot being run by the second defendant. It was being undertaken in the Sydney Harbour National Park, which is where the accident in fact occurred. It was not a paid job, it was unpaid, and it was undertaken in order to add to the plaintiff's portfolio, and she thought it would be of benefit to her in future in securing work and in progressing her career as a model. The first defendant, the model agency, always told the plaintiff she didn't have to do anything she wasn't comfortable with. Before the shoot began, the defendants told the plaintiff of the dangerous nature of the trail she was going to walk along, describing it as treacherous. Nonetheless, the plaintiff agreed to go down the trail, and her injury occurred when she was walking around rocks on the way to some rock pools where she was to be photographed. She slipped off a rock cliff and fell about 4 meters onto a rock formation below. Now, on the way down to this particular point, the plaintiff had to walk past a sign, and the sign, I'm hoping you can see, it does suffer from the stains of graffiti. It reads, "Stay away from edge and do not climb down cliff face," and contains a number of other recommendations. And the evidence of the videographer and cameraman, Mr. Bell, was that as they headed along the track and walked down a set of 5 stairs, which is where the warning sign was, they were there for 5 minutes, took some shots as the sun was coming up, and then made their way along to the second bunker, and they shot additional photographs along the way. He said that it was reiterated to the plaintiff that if she felt uncomfortable at any time, she should sing out, quote unquote, and they could stop. But the plaintiff agreed to, if not insisted on, continuing. The plaintiff at trial said that she had put her trust in the second defendant because they told her that they had done this before. Ultimately, of course, the claim was unsuccessful. The judgment centred on whether or not this activity involved a dangerous recreational activity, and it was found that this pursuit of going to a rock pool for a photo shoot on an unpaid basis was a recreational activity. And taking into account all of the circumstances of the recreational activity, it was held to have involved a likelihood of injury, and the seriousness of injury was high, such that it amounted to a significant risk of physical harm. Thus, it was a dangerous recreational activity as defined. Insofar as materialisation of the obvious risk was concerned, the relevant risk was said to be the risk of slipping and falling while walking on tidal rock pools at Bluefish Point. But what was interesting was the discussion in relation to risk warning. That is found in section 5M of the New South Wales Civil Liability Act. It was ultimately found that the sign that the plaintiff had walked past contained risks of being injured either through the cliff edge giving way or using climbing aids due to the unfenced drop, was not a risk warning of the recreational activity being undertaken by the plaintiff. The risk the plaintiff was exposed to and the recreational activity she undertook was walking on these tidal rock pools, which of course was not part of the warning. This sign did not include the particular risk that was encountered by the plaintiff. thus section 5M couldn't be satisfied. In addition, the court thought that the second defendant's statement to the plaintiff at the car park, where she was told that the path was going to be treacherous and that she didn't have to go on if she didn't want to, did not constitute a warning of the general nature of the particular risk. And so section 5M was not available as a defence in those circumstances. Insofar as the liability of the two defendants were concerned, the first defendant was the agency, Vivian's. Obviously, it was found to owe a duty to take reasonable care, but it was thought that the burden of the first defendant agency, Vivian's, auditing every location and every photo shoot to which the plaintiff might attend was unreasonable, although the burden of passing on information was not. The trial judge thought that even if he was satisfied that a reasonable person in the first defendant's position would have taken the precautions identified, the court could not be satisfied that they caused the particular harm. It was thought that the plaintiff would have undertaken the particular journey, whether she was wearing appropriate footwear or not. Insofar as the second defendant, who were running the shoot, was concerned, the relationship between the plaintiff and the second defendant was not one which fell into a category in which the existence of a duty of care was well established and well recognised. The parties here attended as joint collaborators. The evidence established that the plaintiff was completely autonomous as to her decision to participate or to cease to participate. And in those circumstances, there was no duty of care owed. And you can see a passage from the judgment there on the PowerPoints. In the instant case, the parties attended as joint collaborators. The plaintiff was not in a position of vulnerability with the second defendant. The evidence establishes that the plaintiff was completely autonomous as to her decision to participate or to cease to participate. Consistent with my findings, I am not satisfied that the plaintiff has established that the second defendant owed her a duty of care. From there, we move on. We are still in New South Wales. We're now in the New South Wales Court of Appeal in a case of Men's and the Wagga Wagga Show Society. This was a case that involved a plaintiff who was seriously injured when her horse was spooked and fell on top of her when she was warming up before competition on the second day of the Wagga Wagga Show in 2012. There were some children, some young children, in close proximity to the area where the plaintiff was warming up. They came into contact with a metal sign and it made a loud noise. That noise in turn caused the plaintiff's horse to startle and it faltered and ultimately fell onto the plaintiff and she suffered quite significant injuries. She brought a claim in negligence and also pursuant to a statutory guarantee imposed by the Australian consumer law. She was unsuccessful at first instance in appeal to the Court of Appeal. The primary judge at first instance had based the decision on a number of specific defences, but in particular, the obvious risk of a dangerous recreational activity that, as we've just seen in some previous slides, is found in section 5L of the New South Wales CLA. Ultimately, the plaintiff's appeal was dismissed. The plaintiff had contended that the risk and the conduct should be considered narrowly as being just the noise that was made by the children, as opposed to something wider involving horse riding of this type and in these circumstances. The defendant, of course, maintained that the risk that needed to be considered called for a more generalised characterisation, such as the risk of riding the horse. Again, regard had section 5M of the New South Wales CLA, which requires that a risk warning need not be specific to the particular risk and can be a general warning of risks that include the particular risk concerned, so long as the risk warning warns of the general nature of the particular risk. Section 5M, subsection 5, also explicitly avoids the need to be specific about the risk warning and instead endorses a warning of a general nature. And in those circumstances, the court found that the provision was engaged and that the claim must necessarily fail. Now, there was a consideration of section 5L of the Act, which requires a causal connection between the harm suffered and the risk. Ultimately, it was found that the harm caused to the appellant was as a result of the fall, despite the indirect cause being the noise that had been made by the nearby children. That didn't prevent the conclusion that the entirety of the personal injury could fairly be said to be as a result of the horse being spooked and the appellant then losing control as occurred. And the court, in its judgment, made note of three inescapable facts on that point. Firstly, there is no such thing as a bomb-proof horse. Secondly, that horses may at any time be spooked by a noise, a shadow, or any other stimulus for that matter. And third, that the rider runs a risk of serious injury in the event that a horse is spooked. The appellant in this case had sought to try and distinguish between a warm-up on the one hand and then participating in competition on the other, although the court didn't accept that submission. The court thought that it was just inappropriate in these circumstances to try and separate the warm-up from the actual recreational activity. But in any event, the warm-up itself was in fact a dangerous recreational activity. So no joy for the plaintiff in that case. Finally, some good news for plaintiffs. Back in the ACT, a case of Masuris and Cone elevators, which was only handed down in April by Justice Burns. The plaintiff was one of 4 individuals who in 2013 had entered a lift. The lift malfunctioned when it stopped suddenly, and it caused injury to all 4 of them. The legislation, of course, was the Civil Law Wrongs Act, which we looked at in one of the earlier slides in the ACT, which dealt with both this issue of duty and standard of care, and I had those slides up a little earlier. It was identified that the cause of the stopping nature of the lift, as experienced by the plaintiff and the others in it on this occasion, was due to a defect in the control unit of the lift itself. And the lift malfunction was specifically caused by a poorly terminated wire, which caused in turn an open circuit to the lift drive, which caused the lift to intermittently lose power and come to abrupt and unexpected stops and then restarts in quick succession. Now, all of the plaintiffs succeeded against the defendants. It was found that the defendants could only be liable in negligent if the risk was foreseeable. But it was found that in the lift industry, it's well known that sudden stops for lifts travelling at speeds of the lifts in this particular premises can cause damage to passengers who experience that sudden stop. And it's well known that the risk of injury to a passenger in a lift by reason of sudden stops or descent due to loss of power caused by inadequate maintenance was plainly a foreseeable risk. If the power supply had failed because of no fault on the part of the defendants, then the injuries suffered by the plaintiffs would not have founded a cause of action. But here, that was not the case. The court found that the power supply failure to the lift was due to a lack of reasonable care. There had been a lack of maintenance on the part of the defendants, and the lack of maintenance made this risk a foreseeable one in those circumstances. So a victory for the White Hats, so to speak. Powell, where again back in New South Wales, gee, they're a litigious state, New South Wales, aren't they? Powell and JFIT Holdings, the District Court in New South Wales once again, April this year, the judgment was handed down. The relevant event happened on the 4th of February 2016 when the plaintiff went to the defendant's gym. The plaintiff, Jacqueline Powell, was then 42 years of age. She arrived at the gym to find a floor that was cluttered with weights and other paraphernalia that had been left there by other gym members who simply hadn't put them away after they'd finished with them. The injury suffered by the plaintiff occurred when she had to relocate one of those round 25-kilogram plates that had been left amongst other weights in an awkward position on the floor in the weights area. The plaintiff was simply trying to clear an area of floor space for her to use for her exercise regime to be performed when she suffered the injury to her L4-5 disc. Now, the trial judge found that the plaintiff was an impressive witness, but there are a few barriers to the plaintiff's success. In this particular gym, there was a sign up. I don't know whether you can read that on your screens. It is your responsibility to put away your equipment after you have finished training. Failing to do so may result in your membership being suspended or cancelled. So was the warning. Now, at this time of the afternoon, it was known as tradies hour. None of the defendant's rostered staff had taken any action to either clear or stack away the equipment that had been left on the floor by patrons who had previously used that part of the gym. According to the judgment, at the time, the defendant did not have a rostered supervisory presence in that particular area. So, in order to make use of that area, the plaintiff had to start to clear away and stack weights which were obstructing the floor area. In order to use the weights area in those circumstances, she had to lift and stow the weights by lifting them onto storage racks and weight trees that were provided for that purpose. Now, the plaintiff ultimately succeeded in her claim, although there were barriers, as I mentioned. The trial judge found, first of all, that there was a reasonably foreseeable risk. The gym member might sustain injury when lifting equipment to clear away awkwardly strewn weights which were left in an untidy state on the floor. It was thought that in response to this particular risk, a reasonable person would have taken the simple precaution of requiring staff to inspect the weights area for tidiness and to ensure that the floor was kept tidy. And it was thought that the defendant's failure to do this amounted to a breach of duty. Now, leaving aside the issue of liability, the defendant did contend for a finding of contributory negligence, and that was unsuccessful. But what was of critical importance was the issue of a waiver, as is typically the case. A waiver had to be signed by the plaintiff in order to take out membership at this particular gym. And the waiver rested on the definition of recreational activity, because in this regard, the court found that the clearing up activity being undertaken by the plaintiff in the weights area was not a recreational activity. It was merely preliminary to or preparatory for the recreational activity, drawing a distinction that we've seen before in other cases, particularly in New South Wales. So the court had regard to the provisions of the CLA again, in particular section 5N, which deals with waiver, and then had to consider the issues of recreational activity in terms of the definitions and obvious risks. Obviously, recreational activity under the New South Wales legislation and under all of legislation includes any sport, any pursuit or activity engaged in for enjoyment, relaxation or leisure. But the court concluded that In that regard, I find that a gymnasium-based training program for the purpose of attaining or maintaining physical fitness does fall within the definition of sport or activity for enjoyment, relaxation or leisure, whilst the plaintiff was intending to pursue physical fitness exercises, which can be a recreational activity. The activity had not yet actually commenced at the time she was injured, as she was engaged in the preliminary activity of clearing a space to enable that activity to proceed. The plaintiff had to deal with this issue of a waiver, and one way that she sought to do that was to plead a breach of the Australian consumer law, and in particular Section 60 of the Australian consumer law, which implies into contracts for the supply of services to a consumer guarantee about the services being rendered with due care and skill. As I'm sure you all know, under Section 64 of the Australian consumer law, a term of a contract is void to the extent that the term purports to exclude, restrict or modify, or has the effect of excluding, restricting or modifying any parts of the ACL. And the court found here that the defendant was operating the gym in supplying services to a consumer, and so the statutory guarantee was imposed. And the court went to find, accordingly, I find that neither the purported waiver nor the intended protective effect of Section 5N of the CLA, as contended by the defendant, provides the defendant with any shelter from liability to the plaintiff's claim for damages. As I mentioned before, contributory negligence was pursued in the alternative, but the court found that there was no contributory negligence on the part of the plaintiff. We're now back to the district court. Again, we're in New South Wales. I wouldn't have much to talk about if it wasn't for New South Wales, that's for sure. The plaintiff in this case was a disability pensioner who had attended the celebration of Ramadan at a mosque at Punch Bowl in June 2018. After the ceremony, he was returning to a car park where he left his car. It was a council car park. He was with his 9-year-old son. He took what was a bit of a shortcut through a garden bed where there were no barriers in order to get to where he thought his car was parked. He had to step down a very small step from the garden bed to the surface of the car park. It wasn't a lot. It was only a relatively small step down. The plaintiff gave evidence that he had not taken that particular path before, although he conceded that he had used the car park on previous occasions. The car park itself was nearby to the mosque. It was only about 100 metres or so away. Now, the council denied that it owed a duty of care. It denied breach of duty, and it also alleged contributory negligence. Now, judgment was entered for the plaintiff. It was a relatively modest judgment, $76,000 or so. This fall had happened at night time. It had happened a little after 7 p.m. in circumstances in which the court found that there was no real lighting in the area. The trial judge found that a duty of care was owed, and that the duty was one to exercise reasonable care so that the premises were safe for pedestrians in the position of the plaintiff. It was found that that obligation is to exercise reasonable care to prevent injury to entrants to premises who are using reasonable care for their own safety. And the trial judge rejected the defendant's argument, which was based on Section 5H of the New South Wales CLA, that the risk of harm was an obvious risk. The trial judge found that the effect of the provisions in Sections 5F and 5G is that they may obviate a common law duty to warn, but they do not otherwise affect the question of whether there has been a breach of duty. Now, at trial, photographic evidence from June 2016 showed that at one point in time, access to the car park through that particular garden bed, the one which was being used by the plaintiff at the time of the accident, had in fact been blocked off. But the evidence showed that by 2017, this guardrail had, for some reason, unknown reason, been removed. Because of the proximity of the garden pathway to a toilet block nearby and some shops, the trial judge believed that there was a high probability that the garden pathway would be utilised by pedestrians who were seeking to use that particular car park. The trial judge found, in my opinion, in the absence of any lighting, the probability that a pedestrian in the plaintiff's position walking along the garden path and stepping off it onto the car park at night time in mid-June might not see the potholes is very high. And then when it came to the issue of causation, the council submitted that even if there were negligence on its part, the true cause of the injury was the plaintiff's failure to look where he was going at night time. But the trial judge rejected that argument, and it was thought that factual causation, well, I'll quote, it says, "It is, as the High Court said in Wallace and Cam, simply the application of the but-for test. In my view, but for the negligent failure of the council to take reasonable precautions to prevent the risk of harm, Mr. Abed would not have fallen after stepping into the potholes on the car park." That left the issue, of course, of contributory negligence to be dealt with. The council contended that the plaintiff was contributarily negligent to the extent of 100%. The plaintiff said there was no contributory negligence, as you'd expect. The trial judge found that the defendant was simply unable to prove causation in its contributory negligence argument. And that was because the trial judge thought that even if the plaintiff had been looking down and down just in front of his feet at the time that he fell, instead of looking further ahead, that he would not have seen the hole in the car park in any event because of the darkness. And so in those circumstances, it was thought that the contributory negligence argument must necessarily fail. We're in Queensland. Thank goodness we're in Queensland. We're COVID safe up here at the moment, temporarily. Goondiwindi Regional Council and Tate in the Court of Appeal. Now, this was a case involving a claim by Paula Tate, who was injured in September 2016 when she was riding her motorcycle with a group of other riders on the Leichhardt Highway through the Missingang Creek floodway. This floodway was near Billabilla, about 47 kilometres north of Goondiwindi, so quite a remote part of, I guess you'd call it, southwestern Queensland. The plaintiff had succeeded at trial and was awarded damages in the district court. She suffered injuries when she struck a large pothole in the floodway, which at the time was about 20 centimetres deep and about 30 centimetres wide and about 1 metre long. The background to this, of course, was that in September there'd been a week of unseasonal and considerable rainfall in that region. Now, on the 22nd of September, which was 3 days before the accident, a representative of the council had inspected the floodway and had seen that there was pavement damage and observed that the sealed surface of the roadway had begun to strip and that potholes were beginning to develop. And the council's patching crew attended that day and put up some temporary signage with the words "rough surface" and "reduce speed." And that was erected on both approaches to the floodway. There were no sandbags available because they had been used elsewhere in previous days. No other attempts were made by council workers to secure those signs. By the time the plaintiff and a group of riders happened upon that floodway area, the signs had fallen over, and so there was no warning available. Now, the council was under an obligation under the agreement it had with the state government to manage the road at that section, including signage. The plaintiff had succeeded at trial and the council appealed. Now, the Court of Appeal unanimously dismissed an appeal. The court rejected an argument by the council that the particular risk, insofar as section 37, which you can see on the screen there, of the Queensland CLA is concerned, was the particular pothole which the plaintiff happened upon. And the defendant argued that it wasn't aware of that particular pothole because it was the particular risk that had eventuated and manifested and caused the injury. And I've put section 37 of the Queensland legislation up there. To invoke the section, it was necessary for the plaintiff to have demonstrated that the council had actual knowledge of the particular risk, the materialisation of which resulted in the harm. Now, section 37(2) does not apply in circumstances where the risk that had been identified by council workers was that potholes could develop or worsen, and that if that happened, a road user could be harmed. And the Court of Appeal found that the relevant risk was that risk, the risk that potholes could develop, and that the risk had been identified by the council workers because they had seen the road worsening at that point as floodwaters had been through and receded and cars and traffic had been going over it. According to Justice Morrison, the erection of the temporary signage was plainly a step taken by the council workers to warn users, and in particular those approaching the floodway, that the surface of the roadway was rough and as a consequence their speed needed to be adjusted. I would express that duty slightly differently, but conformably with His Honour's findings. In the circumstances, the duty on the council was to take reasonable care in carrying out maintenance work on the roadway, including installation of warning signage, so as to not create a foreseeable risk of harm to users of the roadway from developing potholes. Here, the difficulty for the council, as I mentioned, was that those who were erecting the temporary signs knew that there were no sandbags available, yet did nothing to secure the signs. It was found that several alternatives were available. For example, the patching crew, as one of the witnesses conceded, could have used a heavy weight, could have used a star picket, could have even affixed the temporary signage to the floodway signs because those floodway signs were permanent. So the appeal dismissed and a judgment for the plaintiff. The last one before we deal with any questions is one of Baker and Bunnings Group. We're back in New South Wales, unsurprisingly, and we're in the District Court. Once again, the plaintiff was a 67-year-old lady. She was injured when she went to the Bunnings store at Port Macquarie in October 2017. She intended to have 3 fence palings cut and reduced in size. She was crossing a concrete island with a view to go into the timber yard at the Bunnings store. There were some raised concrete items there where they were stopped, like gas bottles, pool salt, things like that. The plaintiff approached the timber yard. A car came around through the boom gate, so she retraced her steps and went back around, walked onto this island where there were products stored, and she didn't see that there was a drop from the curb on the other side of the island close to the boom gate. She gave evidence that she thought that the concrete continued without a change in height. She simply didn't see or didn't perceive the height differential, and she fell and suffered injury. Perhaps unsurprisingly, there was judgment for the defendant in those circumstances. It was found by the trial judge that the plaintiff simply didn't see or didn't perceive the height differential, despite her having walked around the concrete island, which has a clear curb without going down a step. Now, in this case, expert evidence had been called by the plaintiff. He was an engineer, which didn't help much because the engineer had made observations about things such as broken sections, which wasn't apparently accepted. But the trial judge found, insofar as duty of care was concerned, that a duty to take reasonable care to avoid a foreseeable risk of injury to her arising from the state of the store or its car park over which a customer would traverse, on the assumption as an element contained in the scope of the duty of care that the plaintiff would exercise reasonable care for her own safety. So we've heard that many times before, and in those circumstances, it was thought that the difference in height between the curb and the road surface would have been obvious. The trial judge went on to say that I do not accept that the measures indicated in paragraph 7.14 of the expert report were steps which a reasonable person in the position of the defendant would have taken. In my view, in light of the oral evidence and the photographs, the step down from the curb was obvious to a reasonable person in the position of the plaintiff. The relevant senior employees of the defendant were not aware of any previous falls from the island. In any event, the risk of the plaintiff falling if she did not exercise reasonable care for her own safety, or the obvious risk in section 5F of the CLA. And then there was an argument about contributory negligence. It was thought by the trial judge that if the plaintiff had established a breach of duty, that there would have been contributory negligence, which was assessed at 20%. So it's interesting that the number of public liability decisions in 2020 to date is down on previous years. Even last year, 2019, had a lower number than was customarily the case. Maybe it's a product of COVID-19, maybe plaintiffs are getting gun shy, maybe defendants are taking a commercial approach and resolving those ones that should be resolved in light of recent jurisprudence, but there's no doubt that numbers are down. Baron, over to you.
Can you hear me, Travis? Yep.
I can.
Okay, thank you. You covered an enormous amount of ground in that short time, Travis. Thank you very much. There has been some questions flooding in. Certainly, I'm going to be a lot more careful next time I'm doing a photo shoot in an aerial sling on slippery beach rocks, around potholes and warning signs covered in graffiti in the dark. And I'm not going to bother asking an expert to tell me if that's safe or not.
I thought your modelling career had ended some time ago, Baron. I heard someone say you had a better head for radio. Not sure what they meant by that.
So first question, in Cornwall, the gymnast that fell from the ceiling in the sling, was there any evidence that the injury may have happened in any event by reason of the mechanism of the injury and the positioning of the wrist when she fell?
Yeah, so a comparison obviously had to be done between, from a causation perspective, in what the outcome might have been on a yoga mat and the outcome on a crash mat, and that was covered off in the judgment. It was considered and it was thought that had a crash mat been used, then based on the evidence that had been called, that there was a likelihood that the risk of injury would have been lower, and also the extent of injury would have been lower because of the absorption qualities of the crash mat as opposed to the much thinner yoga mat.
And then moving on to the Powell decision about the gym weights, moving the larger weights around before getting on with the exercise. Two questions coming out about that one. The first is, was she about to lift the weights anyway? Were they part of her exercise regime?
No, in fact, in Powell, she normally had a trainer. She didn't always have a trainer, but she often had a trainer that she worked with, and she had a program which she would utilize that did not involve 25 kilogram weights being lifted. 25 kgs is, as I'm sure you're familiar, Baron, with your extensive experience in pumping iron in your local gym. It's probably the biggest plate that you'll see. There were a number of them on the floor, and that was the one which, unfortunately, she was having to try and put away on a weight tree when she had to take it out and away and extend and put it on, because there's a little hole in the middle of these weights. And you've got to put it onto the tree like that. That was how she hurt herself.
The next question is, in relation to that same case, presumably she was a member of the gym and there was a contract. Was a contractual claim pursued and would have that made any difference?
Yeah, so this issue of contractual claims is an interesting one. As you know, there's a slight differentiation between the CLAs in Queensland and New South Wales, and obviously, again, in the ACT, as we've seen with their civil law wrongs legislation. In Queensland, the dangerous recreational activity defence is found in Division 4 of our Act. So in Queensland, it's Section 17, and that's found in Division 4. But according to the Queensland legislation, that division only applies in relation to negligence for harm to a person resulting from a dangerous recreational involved in by the person. It talks about a claim in negligence. It doesn't specifically mention a claim based on a breach of consumer guarantee or contract, as is specifically mentioned in the New South Wales CLA. Now, in Queensland, there was a decision of Justice North in a case called Ireland and B&M Outboard Repairs a few years ago now, where in what was effectively obiter, said that there was a distinction between the two pieces of legislation, and in Queensland, because Section 17 was in a division that only referred to claims in negligence, that if there's a claim in contract, he wouldn't have thought that the defence would be available. So to answer that question, no, it didn't matter in PAL because you had the consumer guarantee under Section 60 of the ACL, which is always going to get you home on a pig's back despite the waiver. In Queensland, you've still got Section 60 to try and help you avoid a waiver, but you've also got the contractual case as well that you can run, because if we accept what was said in Ireland and B&M Outboard Repairs, the DRA defence may not be there.
One extra comment that came in, I'm reliably informed that with respect to GRC and Tate, that's subject to a special leave application to the High Court. And one of the issues is whether the council had any power to do anything under its contract with the state so as to owe a duty. That might be one to wait and see. That wasn't framed as a question, but I thought I'd raise it anyway. Came from the audience. Just two more questions. What impact do you think the coronavirus pandemic will have on the public liability landscape?
I think it'll have the same effect, Berin, as it's had in other schemes. Notably, if you look at the various CTP schemes around Australia, since the COVID-19 reduction in activity, we've seen far fewer cars on the road and far fewer accidents. Likewise, in our workers' compensation schemes, there are less people at work, more people working from home, less work accidents. I suspect the same thing applies to public liability claims. If there are less people out and about and being active in public places where they might expose themselves to a public liability insurance policy, that we'll see reductions in claims temporarily. I'm not sure whether it's going to change insurers' appetite, given what's happening on a global basis. I kind of suspect it won't, unless there's something around business interruption policies that spooks people, but certainly from a public liability perspective, I don't think it will have any enormous impact longer term.
Our final question is about probabilistic reasoning. Travis, you coined this term, probabilistic reasoning. Is the use of probabilistic reasoning in judicial decisions still on the increase? And does the increase in the use of probabilistic reasoning generally favour the injured plaintiff or the insured defendant?
Well, first of all, I didn't coin the term. I may have been an early adapter to it. I think it appeared in the judgment in Woolworths and Strong. That was that case involving the Centro shopping centre at Taree with the chip on the floor, where there was effectively no system of cleaning in that little sidewalk area where the chip was, outside the Woolworths store there. And the argument was that, well, there was no evidence the chip had been there for very long because it happened at about 12:30 at lunchtime. The argument went that it could have been dropped 5 minutes before the fall occurred. There was no evidence the chip was cold or had been there for any period of time. The High Court, well, the plurality in their judgment in Strong, said that, well, no, you can adopt probabilistic reasoning because it's far more likely, even if you've got to eat chips for breakfast or a mid-morning snack, it's far more likely that the chip was dropped in a much longer period between 8:30 when it opens and 12:10, which is 20 minutes before the accident, than in, say, the 20 minutes before the incident, which was a reasonable period for rotations of inspection. And that was really, I guess, where this issue or this idea of probabilistic reasoning started. That was probably the genesis in its popularity, at least. Will it make any difference? Look, I think it's common sense, Baron. I think that we are seeing a common sense approach taken in looking at not necessarily the legal niceties around issues of proof when it comes to causation. Causation is obviously the bane of many plaintiffs' existence. I think probabilistic reasoning is fair and it makes sense. I guess the comment I would make is that I'm not sure that the Civil Liability Acts have really made any great difference to jurisprudence in this area of law since 2002, when it was all inflicted upon us around Australia. I think that at least in the High Court and then in the New South Wales Court of Appeal, we're already seeing cases turfed out where they were not meritorious, where the plaintiff couldn't prove their case. I don't know that there are many cases decided under the CLA that would have been decided very differently at common law. Just a personal opinion. Others may beg to differ.
Thank you, Travis. That was tremendous.
Thank you, Baron.
Yes, and your paper will be made available to all the registrants probably in the next couple of days. Everyone will get an email with your paper. So no, that's tremendous. Thank you very much. Just before we close, I've got a couple of more housekeeping points to make. If you go onto the AILA website, you can see links to all of the upcoming other upcoming webinars that we've got. We have quite a few coming up that are all on very broad and interesting topics. There's 2 more this week, one on travel insurance and also one about the insurance code. And then coming up, we have employment law and also eyes forward, future issues in insurance, that's presented by a barrister from Western Australia. And the committees in each of the AILA branches, they're all working hard in bringing more webinars. So there's plenty in the pipeline, so please stay tuned to your usual channels. Please, when you see one that you'd like to attend, register and let your contacts and friends know as well. I think that's about it. Thank you again, Travis. That was a lot of material, a lot of information, and you've managed to condense it all and present it in such a excellent way. And I can assure you, I laughed at all your jokes. So.
Thanks, Baron. Appreciate you having me. Might see you again.
See you.